Welcome to Unit 4. I'm glad you made it this far. I'm glad I made it this far. In this unit, we're going to talk about the issue of indefiniteness. All right, so let's talk about the issue of indefiniteness. Now, remember, to form a contract, to have a legally binding contract, you need three things. You need mutual assent, you need reasonably certain material terms. I'm going to say that again. Reasonably certain material terms, and you need consideration. We've already talked in depth about assent. We will talk about consideration in Unit 5. Now we're going to talk about reasonably certain material terms. And sometimes this issue is referred to as indefiniteness. If you don't have reasonably certain material terms, you have an indefinite contract. And an indefinite contract is not a contract. Let's lay the roadmap for our discussion of indefiniteness. First, we're going to talk about the material terms of a contract. What are the material terms of contracts? Secondly, we're going to talk about what situations give rise to the possibility that a court will say the terms of the contract are not reasonably certain. The material terms of the contract are not reasonably certain. First, we're going to talk about silence, when the parties never agree to a material term. Then we'll talk about vagueness, when the parties are vague about a material term. Third, we'll talk about times where the parties agree to later agree on a material term. And fourth, we'll talk about situations where the parties agree to later negotiate a material term. Finally, we'll talk about the specifics of how the law deals with this. We'll talk about how the common law approaches indefiniteness, and we'll talk about how the UCC approaches indefiniteness. Let's talk about material terms. Remember, when we're talking about indefiniteness, when we're talking about whether a contract is unenforceable because it is indefinite, we're talking about indefiniteness with respect to material terms. Now, keep in mind that no contract is complete. Even contracts that are 200 pages long inevitably do not address every possible issue. What we're looking for in a contract is reasonably certain material terms. Well, what are the material terms? Material terms will vary from transaction to transaction, but this is a good list of what you should be looking for, right? The subject matter of the contract. If you don't have the subject matter of the contract, well, it's difficult for a court to enforce that contract. The price or the compensation or the remuneration in a contract. If you don't have that in the contract, it is very difficult for a court to enforce that contract. For some contracts, the duration is a material term. For some contracts, the time is a material term. For some contracts, such as the UCC, the quantity, right, the sale of goods, the quantity is a material term. And in other contracts, the quality of the goods or services is a material term. So, as we discuss reasonably certain material terms and the issue of indefiniteness, focus on these material terms. All right, let's talk about our first indefiniteness situation, silence. Now, this is a situation where the parties agree to a contract. We have mutual assent, but they never agree to a material term. They are silent as to a material term, right? Here's an example. We have agreement to purchase a house, but the parties never agree on a price. We have an agreement to purchase widgets, but the parties never agree to a quantity. That is the issue of silence. Now, be careful. Some students mistake this to mean that the parties agreed to the price or the quantity. They agreed to the material term, but they forgot to write it into the contract. That is not an issue, right? If the parties really agree to it, then that's their agreement. Right? The situation we have when we are exploring indefiniteness with respect to silence is that the parties just never agreed to the material term. Let's talk about our second indefiniteness issue, vagueness. Here are some examples of vague material terms. a fair price, a sufficient quantity, reasonable salary, top of the line widgets, first class hotel, a big house, average quality. You look at all of those terms, fair, sufficient, reasonable, top of the line, first class, big, average, those are vague terms. Now, there may be a situation where a vague term is no longer vague because it has an accepted meaning. So, for example, if I contract to buy extra large eggs from you, well, there's a standard definition for what constitutes an extra large egg. So, in that case, using extra large would not be vague. Now, let's make a distinction between vagueness and ambiguity. Ambiguity is not vagueness. When we're talking about indefiniteness, we're talking about vagueness, not ambiguity. So here are a couple examples of ambiguity. So imagine I contract to buy chickens from you. Well, chickens is an ambiguous term. What type of chickens do we mean? Do we mean stewing chickens? Do we mean roasting chickens? Do we mean fryers, right? So when a word has several possible definitions, then it is ambiguous. Look at the next example. The lot on the corner of Maple and Vine. So let's say I enter into a contract to buy the lot on the corner of Maple and Vine from you. This is not vague, this is ambiguous. So we can imagine that Maple and Vine cross and there are four corners. So there are four possible meanings to the lot on the corner of Maple and Vine. It's ambiguous, it is not vague. Remember, when we're talking about indefiniteness, vagueness creates an issue, ambiguity does not. Our next indefiniteness issue is agreements to agree. So this is where the parties have mutual assent, they have agreed to a contract, but they agree to later agree to a material term. So here's an example. Landlord and tenant enter into an agreement. Under the agreement, tenant has the option to renew the lease for 2 additional years at a monthly rental agreeable to both parties. Well, that's a promise to agree later. It's a very difficult promise for a court to enforce. All right, now let's talk about our final indefiniteness issue, agreements to negotiate. So once again, we have parties who have mutually assented to a contract, but with respect to some material term, they agree to negotiate later. Right? Here's an example. The parties agree to renew the lease for a rental to be negotiated later. Agreements to negotiate are somewhat different than agreements to agree. An agreement to agree is a promise to agree later. An agreement to negotiate is a promise to negotiate. And you can see that's a little bit easier for a court to enforce the agreement to negotiate. The court can try to determine whether the parties negotiated in good faith.